Hi, welcome back to our Mastering Mobile Marketing series. This is video 1 of 2 on GDPR. I'm Megan and I'm the Senior Strategic Growth Manager at Yodel. Today we'll be covering some of the terminology, the legal basis for processing data and the rights of users. GDPR stands for the General Data Protection Regulation and it acts as an update to the 1995 Data Protection Directive. As you can imagine, there have been huge technological advances since this was put in place, and the collection and use of consumer data has skyrocketed in that time. There is also a sense of distrust from consumers in the wake of a number of high-profile data breaches over the past few years. GDPR aims to rebuild that consumer trust by encouraging education and transparency from businesses to consumers to create a value exchange between the two. Let's now look at the legal bases for processing data. Within GDPR, there are data processors and data controllers. The controllers own and collect the data, whereas the processors process the data on behalf of the controller. Processing includes storage, structuring, and analysis. However, the data controller must have a legal basis for processing. There are 6 options for this. Contractual necessity. This means that the processing is necessary for the basis of a contract, such as a background check. Controller is bound by legal obligation. This is where, for example, a teacher must safeguard a child, and so they must be aware of what allergies they have. The processing protects vital interests, which is where, for example, if someone's rushed to A&E, surgeons can operate with the notion that they'll gain consent after the fact. The priority is to protect someone's life. Public interest, so where the processing is necessary to perform a task in the public interest, such as how UCAS will share information with universities. Consent, so the user is given clear consent that you can process their personal data for a specific purpose. Legitimate interest, where the processing is necessary for your legitimate interest or the legitimate interest of a third party. This applies unless there is good reason to protect the personal data which overrides the legitimate interest. The processing must be lawful, profitable, and ethical. For example, if the processing will compromise the security of a user's personal data, this will override the legitimate interest. For most businesses, the basis for processing will fall between consent and legitimate interest. Legitimate interest may seem the most appealing and the easiest to implement. However, it will be essential to first carry out an assessment to determine whether your legitimate interests are balanced. It will also be critical to introduce safeguarding, such as data minimization, privacy by design, and adding security measures. This shows that you have properly considered the implications of the processing. On the other side of things, consent under GDPR must be informed, verifiable, and freely given. This means the end of the practice where all rights are bundled under the T's and C's. Users must clearly understand what they are opting into. Pre-ticked boxes or inactivity, common practices for direct marketing and cookie opt-in, will no longer count as consent. This means that marketers and product owners must redesign their registration processes to make sure that consent is collected in a lawful way. Let's now look at the rights of users. It's important to note that with many of the bases of processing comes more rights for the user. These rights are: right to object to marketing and profiling. The user must be made aware that they have the right to object to any profiling, which is automated decision-making based on a person's behaviour and preferences. This could be anything from analysis for a credit card application to direct marketing emails based on someone's behaviour. The user also has the right to be forgotten. This is the right to erase personal data and to restrict any data tracking moving forward. We also have the right to data portability. Users can ask that data held on them is transferred to a new provider in an electronic format. And lastly, right to subject access. This is where users can ask to see what data is held on them, and the company cannot charge for this request. So, your company must have the structural capabilities to fulfill some or all of these requests, dependent on the basis for processing. Please join me in part 2 on GDPR, where we'll talk about some of the ways that you can prepare for the new law. But for now, please hit thumbs up and subscribe if you enjoyed, and don't forget to check out some of our other videos in the Mastering Mobile Marketing series. Thanks for watching.